Hi, everyone. This is Dave Stauss. I'm the practice group leader for Husch Blackwell's Privacy and Cybersecurity practice. Today's on-demand webinar is, as you might suspect from the title, an overview of the Utah Consumer Privacy Act. We're not going to dig into every nuance of the Act, but rather we will provide the listener with a high-level understanding of the Act and its provisions, as well as some of the ways that Utah compares to the laws in California, Colorado, and Virginia. With that, let's get started. Perhaps the best place to start with discussing any privacy law is the applicability provisions. Utah has a familiar applicability structure, although it introduces a new wrinkle. So, reading left to right on this document, you can see it's got that familiar concept of the controller or the processor conducts business in the state or produces products or services that are targeted to the residents of the state. However, moving to the next step, Utah creates a wrinkle where that entity must have annual gross revenue of 25 million or more. Now, the listener may be thinking that they recognize that from California, but remember, in California, that is one potential threshold. So you can have 25 million or more, or you can be processing the personal data of 50,000 consumers, households, or devices. That will become 100,000 consumers or households personal information when the CPRA goes into effect, and then also be a data broker. So it's one of three, the 25 million being a triggering threshold. Here it's a threshold requirement, just period. And that's different than in Colorado and Virginia. Okay, now if you move to the third column, you see the familiar other requirements here. That's the 100,000. The entity would have to control or process the personal data of 100,000 or more consumers, or essentially be a data broker. Now, the definition of consumer obviously becomes important. It's defined as an individual who is a resident of Utah acting in an individual or household context. It does not include an individual acting in an employment or commercial context. Familiar concept as what we see in definition, as what we see in Colorado and Virginia. Sale becomes important as well. Obviously, in the context of data broker, sale is defined as monetary consideration. It does not include the phrase other valuable that we see in laws such as Colorado and California. Personal data, also an important definition here. That is information that is linked or reasonably linkable to an identified individual or an identifiable individual. It does not include de-identified data, aggregated data, or publicly available information. In addition, at the end of the statute, you'll see that controllers are not required to re-identify de-identified data or synonymous data. Okay, like the laws in California, Colorado, and Virginia, there are many, many exemptions. Comparing Utah against those other laws, Utah is comparable in structure to Virginia. It provides broad entity and data level exemptions, just like the Virginia Consumer Data Protection Act. You see here the GLBA financial institution and entity level exemption, HIPAA covered entity exemption, nonprofits are exempt, and educations of higher education institutions and FERPA regulated data. Now, in comparison, if you looked at, say, California, that would just be a GLBA data exemption, not the entity level. In comparison, if you looked at Colorado, nonprofits are not exempt, and then certain higher education institutions are not exempt in Colorado as well. But again, this model follows the Virginia model of broad exemptions. And just providing a few more pages on this or examples, you have your FCRA data. And just to tease out here, the employee, independent contractor, job applicant data. As you'll recall from a couple slides ago, the definition of consumer excludes employment, an individual acting in an employment or commercial context. However, there's redundancy here where you see this exemption as well for this employee data as well. It's very consistent with what we see in Colorado and Virginia. So these are some exemptions. I encourage you that if you are looking to comply with this law, to go ahead and take a look at the full listing of exemptions. Like I said, there are many, but these are the high-level ones here. Okay, moving along, we're turning to data privacy rights. And you see here that Utah provides 6 rights to Utah citizens, or the law will provide 6 rights to Utah citizens. These rights will be familiar to those who are already familiar with California, Colorado, and Virginia, but there are important distinctions. If you look at the right to deletion, that only applies to data provided by the consumer to the controller, and that can be significant. That's not all data that the controller has. That's data that the consumer has provided to the controller. So, for example, if you think of like data brokers who are collecting data on individuals from multiple sources and probably not collecting it from the consumer, that becomes an important qualification of this right. The same limitation applies to the right to data portability, number 4 there. What you may not see is what's missing. There is no right to correct inaccuracies, and while there is an opt-out of targeted advertising and opt-out of sale of personal data, there is not a right to opt out of profiling. Sort of tease these out and put this into context with respect to the frameworks that you may already be familiar with. This is a chart that compares California, Virginia, Colorado, and then Utah. We are getting our fill of acronyms on this page for sure. Just to highlight the yellow check marks, what do those mean? That's where there's the right is limited by the consumer. It's that qualification I talked about before, right? That we're talking about data that is directly collected from the consumer, not all data in the controller's possession. So you see that with respect to portability and deletion in Utah, that limitation. And then with respect to the yellow check mark for not be discriminated against, the reason we've got that there in Utah is there is some interesting qualifying language there, which says the controller may offer a different price, quality, selection, etc. if the consumer opts out of targeted advertising. It's sort of this concept of you have the right to discriminate if the consumer opts out of targeted advertising. So a big qualification on the right not to be discriminated against in Utah there. Moving on and just sort of teasing out a few more of these rights. We talked about this in the previous slide, that you see that Utah does not provide the opt-out of certain types of profiling that we see in other statutes in California. If you're looking for it in California, it's in the rulemaking process that's going to have to go through by the California Privacy Protection Agency. And then we've got this yellow check mark with the opt-out of sale. That's because there is an extra exception in Utah where the purpose of disclosure is consistent with a consumer's reasonable expectations. Some broad language there. And I suppose that the controller gets to determine whether the use and disclosure is consistent with the consumer's reasonable expectations. As you can imagine, that's a very powerful exemption, so that's why we have it marked in yellow. Okay, consumer requests is the next stage here. This looks familiar to those familiar with Colorado and Virginia, with one important distinction. There is no duty in the Utah law to create an appeal procedure, such as that is found in Colorado and Virginia. Colorado and Virginia have a provision whereby you are supposed to provide a mechanism by which, if you deny a request, you can then have an appeal procedure where the consumer can appeal that denial. That just does not exist in Utah. Otherwise, it looks fairly consistent with the Colorado and Virginia structure. With respect to sensitive personal data, this is again an area where we see divergence in the Utah law with respect to the other laws, California, Colorado, and Virginia. Sensitive data is defined in the Utah law similar to what you see in Colorado and Virginia, and that is personal data that reveals an individual's racial or ethnic origin, religious beliefs, sexual orientation, citizenship or immigration status, medical history, mental or physical health condition, medical treatment or diagnosis by a healthcare professional, and then the processing of genetic personal data or biometric data. However, it has to be processing for the purpose of identifying a specific individual. And then the final category is specific geolocation data. Geolocation data is in Virginia. It's not in Colorado. There are some qualifications about what sensitive data does not include. Not going to go over them, but just be aware that comparing these definitions is really important. We've gone through, as I think readers of our blog know, we've done an entire article comparing California, Colorado, and Virginia on this exact issue and how they treat sensitive data and biometric data. I encourage you to take a look at our blog if you have not already done so, and we'll have a slide that directs you to that blog at the end. So with respect to how the treatment of sensitive data is going about in the Utah law, the broad divergence here is that top box, no consent required. If you know Colorado and you know Virginia, the requirement is that controllers need to have consent for the collection of sensitive data. That is not how Utah approaches it. It turns it on its head, and instead it says you need to provide clear notice and an opportunity to opt out prior to collection, right? So conceptually, before it's collected, you provide a notice, a clear notice, and have an opportunity to opt out prior to that collection. I think there's a lot to be thought through with respect to how that's going to be operationalized moving forward. Again, Colorado and Virginia, it's consent. California, those you will remember, California addresses this with a right to limit the use of sensitive personal data. Businesses can use personal data, but only within a certain box of purposes. If they stray outside of those purposes, then they have to provide consumers with the right to limit the business's use of that information back down to those purposes that the statute allows for. So very, very different approach in Utah as opposed to the pre-existing states. And then finally, on the last two boxes there, there's some variations in the definitions with Utah law. It's just essentially tease those out on a slide there for your benefit. And also, as it concerns sensitive data collected from the consumer, again, it's not data received from a third party. It's not inferred data. It's only with respect to data that's collected directly from the consumer. Okay. Privacy policy, all very familiar concepts here. The controller is required to provide a privacy policy. There's nothing groundbreaking here. No requirement of the notice at point of collection other than what I talked about before with the sensitive data. And here you see just, frankly, just fairly typical disclosures on what the privacy policy needs to state. Nothing out of the ordinary with the pre-existing California, Colorado, and Virginia that you're used to. With respect to data processing agreements, you may be familiar with this concept from Colorado and Virginia that you're going to require to have data processing agreements in place for the transfer of personal data to processors. And Utah tracks Colorado and Virginia, except it does not include three pieces that are in those laws. For example, as compared to Virginia, if you're looking at the Virginia statute and you're comparing against the Utah bill, Virginia would require a provision addressing the return or deletion of data at the conclusion of the engagement. Virginia also requires processors to make available to controllers all information necessary to demonstrate compliance with the law. And Virginia also requires processors to allow controllers to conduct reasonable assessments of the processor or to arrange for an independent third-party assessment. So again, Utah here, again, is much more business-friendly, at least in the context of these data processing agreements. The limitations are going to be familiar to you. This is essentially, the law does not require you to do X, right? You can cooperate with law enforcement, you can fulfill warranties, you can protect life or physical safety, you can perform a contract. There's a water's edge at what the Utah bill will essentially require. And this is, again, it's a very familiar concepts as Colorado and Virginia and even California. So this is a big slide. This is a big slide for those trying to understand the Utah bill. This is essentially, a list of things that are required in California, California, Colorado, or Virginia. Not all of them are required in each of those, but these are things that are found in some or all of those laws that are not found in the Utah law. So when you hear a discussion of Utah being a more business-friendly law or bill as it is currently, it hasn't been signed by the governor yet, but as you hear that conversation about being more business-friendly, in addition to everything I've talked about before, these are the big ticket items. There is no duty to recognize opt-out signals that is going to be required in Colorado, and it's going to be permissive in California. There's no duty to perform data protection assessments. This is going to be required under all three, California, Colorado, and Virginia. California is going to be teased out in rulemaking. Not there in Utah. Very significant aspect that's not there. No consent for secondary use of personal data. That's something that you may be familiar with as a specific provision, for example, in the Colorado law. And then, also the specify the express purpose for which personal data are collected and processed. Again, Virginia and Colorado examples of where that's required. Number 5 is data minimization. You see these concepts in other laws that is missing in Utah. And then there's no prohibition on the use of dark patterns. For example, you see that in Colorado. So again, these are more ways in which the Utah law is much more business friendly than, say, the existing, I keep on saying law, but it is a bill right now. It's expected that's going to be signed shortly by the governor. But these are ways in which there is divergence from Utah. And also worth noting, there's no attorney general rulemaking in Utah like there is in Colorado, and obviously the California Privacy Protection Agency is going to be doing rulemaking in California. Enforcement is, there's no private right of action. No surprise there. I think you probably would have heard about it. If there was a private right of action, there's no private right of action in the Utah bill. It's attorney general enforcement. There's a 30-day right to cure that does not sunset. The right to cure is going away in California. It will sunset in Colorado. It will not sunset in Virginia. So this matches Virginia. And there you see, the ability to seek actual damages or statutory damages. Okay, as far as effective date goes, going from left to right here, this is what your future looks like. You see California, the CPRA or CIPRA, as some people call it, and Virginia are going to go into effect Jan 1, 2023. Of course, in the back of your mind, you're probably thinking with California, we still need the regulations, and we absolutely do, and we'll kind of see how that plays out. Colorado then is next up to the plate. They go into effect, there will be July 1st, 2023, and then Utah would follow at the end of 2023. And we'll see if we get any other states that jump in and add to these effective dates. Okay, for those who are interested, I mentioned it previously, but we've been running a 10-part series on our blog comparing various provisions in California, Colorado, and Virginia, and I suppose we will be at some point in time adding in Utah to this discussion as well, and just taking all these provisions we've been talking about and really getting into the nuanced and very detailed analysis of them. So if you're interested, I encourage you can use the QR code to get to the blog and to get to these articles. And then finally, I mentioned the blog a few times. We encourage you, if you're not already subscribed to the blog, to go ahead and do so. You can get to the blog by using that QR code there. We do our best to try to keep everyone updated on the latest developments. With that, I would like to thank you for listening in on this on-demand webinar, and we look forward to chatting with you soon. Thanks again.